Hi there. Welcome to the program today. Peter, thank you so much for having me today. We're going to give everybody a few more minutes to kind of catch on to their devices there. Maybe you want to say a few words before we get going here.
Terrific, Ted. Thank you so much for doing this evening. This is a really excellent opportunity for members of our Paros family to learn a little more about what might be right for their families as far as a will versus a trust, and those really complicated and difficult decisions to make among their households. We're really thankful to be able to present. Well, obviously, we're not presenting. We're really thankful that you and your team at Cusack and Associates in Illinois there are willing to do this presentation for us and our members and our friends, so they can learn more, again, about what's right for their families and to help maybe start thinking about that process. I can take a minute while we're warming up here and people are signing on to talk a little bit about our most recent initiative at the Paros Foundation. After the war in Artsakh, the refugee crisis that was created is extraordinary. There was 100,000 people that had fled the war zone and moved into Armenia. Now about half of them have gone home. And now you're left with this 50,000 people that are essentially homeless. Their homes were lost, and they are thinking about either not returning or staying in Armenia perhaps, or moving to another country to try to find an opportunity. So the Paros Foundation has launched an initiative to resettle these families as quickly as we can in some of the communities that we've done a whole bunch of work in, some of the rural communities specifically. So we're looking at taking rural families from Artsakh, purchasing them homes, buying them furniture and appliances, moving them into a community that has a nice school, running water, decent utilities, and an opportunity for them to restart. We've formed a coalition with 4 other partners that we'll be talking about soon publicly to do this work together, so we can even help resettle more and more families. And I'm really, really thankful for this opportunity. And as we move forward, and of course our dogs decided now's the time to chime in, so I apologize about that.
The beauty of
But
work at home.
yeah, exactly. This is what happens when we move to the resettlement phase. We'll start announcing publicly the families, the communities we're buying and moving families into, and the goal of getting them set with new roots, deep roots, so that they stay and thrive in Armenia. And we can help make the best out of this really awful situation that we have now of lost territory and this refugee crisis. So that's our most current project that we're working on. Obviously, a lot of our other work is on our website, and we continue to do those things. But tonight, the goal is to talk about what's best for you and your families, a state's plan, either a will or a trust, and what the differences are. This is the second one we're doing this evening, and I learned an awful lot, and I've actually done some planning with our family. So stay tuned, and Ted, take it away. And thank you so much again for taking time to do this for our members and the community, and it's all yours.
Well, thank you, Peter. And it's been a long time since I've done a double header, so hopefully I'll have good energy for this program as well. Thank you so much. It's an honor to be invited to speak on behalf of Paros and your constituents and your donor base. And I hope that we can bring some value to the table today. I do kind of want to make a disclosure up front. I am talking to you from Illinois, and I am licensed in Illinois, but we do work with well counsel attorneys, which is part of an association I belong to around the country. So if you need to consult with us about anything, we will use counsel locally to make sure that you're covered in your jurisdiction wherever you are. Today is going to be specific to Illinois and federal. So whatever's happening in your state, I may allude to a little bit of what happens around the country in other states, but you need to get counsel in your state licensed to help you in that state. So again, thank you, Peter. We'll, if you're available, maybe we'll check in with you at the end of the program and say goodbye in about an hour. Is that all right?
That's just perfect. I look forward to it.
Great, great. Well, we'll say goodbye to Peter for now, and in a minute or so, or a second or so, we should have a slide up here. And when I get the cue from my associate who's acting as producer today, we should be good to go. So, if you haven't already, take a look at the slide and take that number down, 847-940-7780. You can always go back to our webpage and get that if you want to contact us about anything, or if some of the technology for sending an evaluation or trying to set up a meeting doesn't work. The phone always works. Just give us a call. We'd be happy to follow up with you that way. So I'm going to start by saying we are a firm. I'm not one individual attorney. There are three of us. We're all separated apart by about 15 years each. We plan to have bandwidth through 2060 right now to take care of clients, and we are hiring. So if you know another attorney in Illinois that's interested in getting into the legal side of estate planning, we do training as well. Have them give us a call. We're expecting to be here not only for our existing clients, but their children and their children's children. So if you know a way to help us out with another new associate, we'll probably be hiring someone within the next 5 years or so to get the right fit. So I'm going to start by asking a question, and I will tell a couple of jokes from time to time. Kind of wondering if you've ever, and by the way, you'll see my phone here from time to time. This is my slide advancement machine. I'm not checking text messages during the program. Have you ever left babysitting instructions? Either you have a child or you know someone that's had a child. At any rate, you know, at some place, parent's going to go out to dinner maybe, and they're going to leave the child behind with someone besides a grandparent, and they leave some really good instructions. So what do? They go out to dinner, they get there, and what's the first thing they do? Well, they probably pick up one of these, right, and they call home. Why is that? Well, they want to check in, for one, and number two, they might have forgotten to say something, and so they want to adjust those instructions. That's the great thing about being alive, is that we could always call home and change our instructions. So the question I'm going to put to you today, though, is what kind of instructions will you want to leave behind when you're going to go away forever? As far as I know, where I'm going to talk about going to tonight, you can't call home. But that was a joke. When I tell this live, I usually get a couple of laughs. It's kind of strange to tell jokes to a camera, but so be it. That's the world that we're in right now. Our firm believes a few basic things. First of all, you should control your property, giving not only what you want, to whom you want, but when you want and the way you want. If it's your intention to leave money to an 18-year-old for a college education and you don't want them blowing it on a fast car, you better have some good instructions. And then most people want to do this at the lowest possible cost, minimizing taxes, probate, and legal fees. We're going to talk about three issues today revolving around estate planning: living probate, and death taxes. And though I could lay out for you a number of different areas of the law, rather than do that, I'm going to tell you a story. The story's about Bob and Pam. They're married. They have a $2 million estate. Two questions come to mind. Ted, I'm single, I'm widowed, I'm divorced. We're going to cover you. My estate's not exactly $2 million. Guess what? Neither are my clients. They're either smaller or larger. We're going to cover you as well. So just pay attention as we go. I think we'll probably hit everybody before the program's over. We're going to start with Bob and Pam married, though. And the circulating arrow on the top means they want to control everything between the two of them. And then when the last one perishes, they want to give half to Susan. She's that perfect child in the family. John's on the other side of the spectrum, the not-so-perfect child. Took a wrong turn in the 1970s. And maybe you've got children on both ends of the spectrum, or maybe no children at all. You're leaving money to certain beneficiaries. But my guess is, even if they're kids in your own family, they're different. And it's important that the lawyer who's helping you plan your estate understands their differences. And the only way they're going to be able to understand that is if you take some time to share some stories about those individuals so that the lawyer can properly create something to meet your circumstances. But if it takes time to share those stories, do you want to pay that lawyer by the hour? In my opinion, no. And the reason is, when I pay by the hour, I rush. And this is a process that can't be rushed. In my opinion, you need to have some period of time to freely share information without the risk of cost. We'll talk about how lawyers charge for this service before we're done today as well. We're going to look at some planning choices for Bob and Pam. Actually, we won't look at the do nothing. I'm assuming you're not on this Zoom or this YouTube to do nothing. We'll look at holding assets in joint tenancy, a very common way that people plan. A simple will, another common way that people plan. And then a living trust, the growing trend in estate planning. What's joint tenancy? Well, it goes like this. Two people own something together, right? And one of them passes away. The survivor owns it automatically because they're deemed to have owned 100% of it from the very start. If you understand the last one standing in joint tenancy wins, you basically understand joint tenancy. What about a will? Well, it has to be in writing, and then it says where your assets go when you die. So what has to happen to you before your will can take effect? You have to pass away. That means it can't do anything to help you while you're alive. And in fact, while you're alive, it's a worthless piece of paper. It has effect only when you pass away. So in our example, Bob got sick, laying in a coma. Not expected to die, they just don't know when he's going to wake up. Pam is going back and forth to the hospital, and at some point she says, you know what? When Bob is out from under this, we're not going to be able to live in that house anymore. It's got steps. We got to sell that house. Okay, what do I got to do? I want to sell that house. But the house was either in joint tenancy, which means Bob and Pam's name were both on there. So if she wants to sell it, she needs 2 signatures. Or maybe the house was in Bob's name before they were married, and he wrote a will that says, my wife gets the house when I die. In either case, can Pam sell that house by herself? And the answer is no. She has to go to the probate court. Since Bob is living, we call that living probate. What is it? It's a lawsuit designed to protect the person who's disabled. It sounds pretty decent until you really understand the mechanics of it. The first thing that Pam does is she goes to court. And the first thing the judge does is decide if Pam is responsible enough to be the guardian. The first area where we could lose control. Let's say the judge agrees. What did she want to do? She wanted to sell the house. So she lists it for sale. She gets a price. Who decides if that price is good enough to protect Bob's interest? Once again, it's the court. Now she's got money. She sold it. She wants to invest it. Who's going to decide what the investments are? Who's going to decide on what the proper spending habits are? All of these have the potential for being issues that the court is deciding. All issues where we could lose control. So how long does this process usually go? Well, for most cases, you don't remove a guardian once they're established. So it's going to be until the person dies. So now Bob has passed away. How are we going to distribute his property? Well, now joint tenancy and the will operate differently. Remember what I said with joint tenancy? Whoever lives 1 second longer gets it. So Pam would automatically own that house. But what if Bob owned the house in his own name and his will says, get it to my wife when I die? She doesn't get clear title until the will is probated. Let's talk about what death probate is. This is the one that most people are familiar with. It's the legal process of transferring the assets into the heirs' names, getting it from a dead person's name, Bob, into Pam's name. What's the primary purpose as far as the court is concerned? Make sure the bills are paid. So when the lawyer files the will, they file a legal notice. And that legal notice is publication to the world that if you think Bob owes you money, now's the time to come get it. That runs in Illinois for 6 months. Once that's done, then they can try to administer and close the estate, which is the process of changing the title of the assets into the names of the live beneficiaries. Like I said in our example, trying to get it out of Bob's name into Pam's name. You're also going to have to resolve any disputes there. You know, Uncle Bob said he was going to leave me some money. I didn't get it, so I'm going to file a claim against the estate, and then maybe I'll get a settlement. By the way, if you're in a second marriage situation, you need to be a little careful. Maybe when you got together, you decided you've got your own families and your own assets, and you're going to leave them to your respective families. Now you're married. Well, under Illinois law, if a surviving spouse wants to, even though they're not mentioned in their deceased spouse's will, can claim a third of the estate and get it by law. So if you're in a second marriage situation, you need to be careful that you have the right planning tools to effectuate the transfers that you want to make. Inventory and appraise all the assets, and finally make a distribution of the assets to the beneficiaries. But as you can imagine, it can be expensive. There's attorney's fees, filing fees, executor's fees, bond premiums. Of all the different things that we consider probate fees, what do you suppose winds up being the lion's share? You can imagine it would be legal fees. So lawyers get paid around the United States 2 ways. Illinois lawyers are paid what's called reasonable compensation, and that's about half of the state. So it's hourly times the number of hours and whether the hours spent were reasonable, right? And then there's percentages. So some states, like California for instance, have a percentage jurisdiction, and they say we're going to give the lawyers a percentage based on the size of the estate. And we're going to arbitrarily call that fair. That way we don't have to get into hours and whether the lawyer spent as much time as they were supposed to on the case. So let's take a look at what that might be. So in Illinois, I did a trust for a probate lawyer in 2016. And what he told me was Illinois lawyers, well, at least he did, charged about 5% on average. So the reasonableness, when it was all done, wound up being about 5%. So at a $500,000 probate estate, you would look at $25,000 in probate fees. National programs that run this for your major brokerage firms, if they do an estate analysis, they almost universally plug in 4%. And so if you used 4%, then do you think that's 4% of the market value of the assets or the equity value of the assets? Well, we would hope it's the equity, but in most of these states, it's the fair market value. And when you think about it, that kind of makes sense because if you had, $1 million worth of assets and you had, $990,000 worth of debt, well, you wouldn't think that your probate fee would be based on $10,000, would you? No. So it actually has some logic to it, but in this particular case, $12,000 would outpace the equity, by 12 to 1. And this would never happen. This is a hypothetical example, obviously. Disadvantages of probate also are like this. So public record. Chances are you don't want to share, your financial information with even your closest friends, right? Yet in probate, the probate files are all public record. This is a court record, so you can get it. So you don't have to be a lawyer. You just go to the clerk's office and you ask to see the file. And when you open it, you'll find an inventory, list of the assets, the debts. So what was your mortgage, your car payments, your cable bill, your magazine subscriptions, whatever else you got that had to be paid. And then you'll find the will. And what you see there is the distribution pattern. So who got everything? Not only does someone know what you had, they know who has it. And if we don't want people to know about this while we're alive, do we really want someone else to be able to figure it out when we're gone? There's probate in every state. So if you happen to be in one state, but you've got a second home in another state or other real estate, there's another lawyer in that state licensed to do probate in that state. And again, if you came in later in the program, we're talking about Illinois specifically today. I'm going to do some federal discussions, but we're specifically kind of drilling down into Illinois today. And then obviously that's going to run up additional costs and fees. We know that probate's public. We got potential multiple probates. What about death taxes? So there's two kinds of death taxes. There is federal and Illinois estate tax. I'm just going to ask my assistant right now, Michael, can you grab my iPhone charger? My remote control is going to go dead before we're done here. Yeah, there's one right there. Perfect. And if you could just plug that in down there, we'll do our best to extend my reach. This is our second power issue today. The first program I did, we had the, oops, that's not going to work. I'll have them get back to this again. Illinois basically has its own tax, and if you think of the exemption, which is $4 million, like a coupon, the tax kind of works like this. If you've got up to $4 million, you apply this coupon, and it covers the tax. So in essence, there's no tax on the first $4 million. But what do we know about coupons? At some point, they expire, and this coupon expires when you do. So 9 months after the date of death, that $4 million coupon in Illinois expires. Now, I don't know if that's the case for every other state, but that's the way it is in Illinois. So I'm going to show you how to cover that extra coupon if you're married, so you don't lose one. And then the federal tax, the rate is much higher, 40%, but the coupon value is also much higher. It's $11.7 million. So what that means is up to $11.7 million, this coupon wipes out the tax. That's a coupon as well, but you can save it in other ways, which I'm not going to get into today. It's a little bit more technical than today's conversation allows. And then there's what's called an unlimited marital deduction on the federal side, which applies in most states as well. And this marital deduction says you can leave as much money as you want to your spouse and pay no tax. And that sounds great. Why would I say it's a trap? Well, here's how. Let's say that in Illinois, at any rate, Howard Hughes was living here, and he died, and he left $5 billion to his wife. So the tax at that point would be zero, right? Because there's this unlimited marital deduction. But 9 months after Mr. Hughes dies, what happens to his coupon? Hang on a second, I'll just put that in my pocket. Perfect. All right, now we're all powered up. So 9 months after he dies, the coupon expires. So I'll show you how to preserve that coupon, but we can't just leave everything to our spouse and expect that coupon to be maintained. The federal exemption, or coupon, if you will, has been rising steadily since you see in this chart of 2002, and right now you'll see 2021, it's at 11.7. Now that law will sunset, which means it goes away by itself at the end of 2025, and then it resets back to the year 2010 where it was $5 million, and then it goes forward based on an index. So based on the index, it'll probably be about $6 million. So if you plan to be alive in 2026, and most people that come to see me think that's going to be the case, then that's probably the federal number that you want to look at, somewhere between $5 and $6 million as a credit. There's some other tax laws on the federal side you need to be aware of. The $10,000 annual gift exclusion is $15,000 now, and that's $15,000 from one person to another person, as many people as you want. And then there's a lifetime exclusions for the coupon right now. So if you had a very large estate, let's say $100 million, and you know that this coupon 11.7 is going to go away in 2026, you can use it now as a gift exclusion, and the same coupon applies, but you don't get another coupon when you pass away. So use it. It's not like Bed Bath & Beyond. You can't use it multiple times. It's a one-time, one-use coupon. So if you're below 4 million, do you have any federal tax? And the answer is no. We know that because the exemption is 11.7 million, and no Illinois tax because that's the limit, 4 million. But do you have probate? And the answer is yeah. And in most states, that's going to be the case. In Illinois, for sure, because anything over $100,000 is considered a probatable estate in the state of Illinois. And other states have various levels, but that's where it is here. So you're still going to be stuck with living probate. If you get sick, someone's got to become your guardian, and you're still going to be stuck with death probate. Got to figure out who owns those assets when you die through a court system. So joint tenancy, or the simple will, from a tax perspective, have everything going to the survivor. And that's my Howard Hughes example, and that makes sense at the first death, but not so much on the second death. So Pam's now a widow with $2 million, and a spouse will typically live for a period of time. The average, I think, is about 7 years. And over that period of time, generally speaking, assets will grow. There's one less mouth to feed. The survivor gets more conservative in their spending habits, and inflation takes over at 3%. Homes value over a 20-year average about 5%. And obviously, there's been wild variations in this over time, especially recently. The market, again, wild variations. I'm not going to get into the market and statistics and things like that. I'm just going to use simple math. So you don't need a calculator for this. At 7%, which is my example, in 10 years, money doubles. I don't know whether you can get that or not. If you want to say it's 3.5%, then it's going to take 20 years. At any rate, in my example, the money doubled. And then PM became disabled. Who's going to manage your property? Well, we know that joint tenancy doesn't help anymore. It's gone. That went away when Bob died. And a simple will. Well, we know that a will by now, if the word will in your mind equals probate, you understand what we've been talking about. So we need a guardian. Who's the court going to choose? We don't know for sure, but we know that Pam won't be making that decision. It's going to be up to the judge, and then Pam passes away. So now is when the will goes through probate. And for most married couples, this is when probate happens. Unless you specifically, as a married couple, own assets separately, you probably own them jointly, in which case there probably won't be probate at the first death. It's the problem you leave your children. That's usually the issue for most people. But let's just say the worst case scenario, there were 2 probates. Well, you could have spent $120,000 in probate fees. Let's pare it down. Let's say there was only 1 probate. So now we're subtracting Bob's probate. You see the $40,000 coming out there. And then we get probate done at half price, right? Instead of $160, it's $80. Is anybody finding this inexpensive yet? Cut it in half again. Now we're at 1%. Again, any number I put down there is probably going to be more than families would willingly pay if they knew they had another alternative, which we're going to get into in a moment. And then there's estate taxes, which are due 9 months after the date of death. So let's summarize what I've talked about so far. We're trying to avoid living probate. Bob got sick, right? Joint tenancy? Nope, no help there. Simple will? Nope, no help there. Avoiding death probate? Bob died. Yep, joint tenancy helped us there. What about the will? Nope. If Bob used a will when he died, we're going to have a probate then. Second death, joint tenancy is gone. Again, no help. Simple will, by now, again, the word will should equal in your mind the word probate. And if we're trying to avoid federal estate taxes, joint tenancy and the simple will have us giving everything to a spouse. And we know that when we do that, we're not going to save money on death taxes. At least in Illinois, we're going to lose one of those coupons. Other problems of joint tenancy, gift tax potential. Every once in a while, I'll have someone come into my office and I see that a child's name has been added to the deed. It's typically a mom, and a real estate lawyer put the child's name on a piece of real estate. Well, when that name was added, a gift was made to that child of 1/2 of the value of the property. And I've already talked about gifts. How much can you make in a gift in 1 year? $15,000. So unless you live in a $30,000 home, we potentially got a taxable gift, probably didn't get reported, probably going to create a problem down the road, probably going to create capital gain taxes that didn't need to exist later on after you passed away. Not a good idea. Passing property to an unintended heir. Here's a situation. You probably don't have to drill down in your family tree too far before you find a situation like this. Husband and wife are married. The husband passes away. Through joint tenancy or simple, he leaves everything to his wife. And now she gets remarried. Now, she dies before the second husband. She was a little younger at first, but now she's older than her second spouse, and he outlives her. He had some kids of his own. She dies. But she got assets from her first husband, which now are in joint tenancy with the second husband. Who gets the assets? Well, it's the second husband or the children. Second spouse, depending on the relationship, right? It doesn't have to be husband and wife. It could be husband and husband, wife and wife. But it doesn't matter. If you leave things to your spouse and they remarry, then that next spouse would have the potential of inheriting the assets, not the first family. Advantages, creditors. You add someone on your account. As soon as you add them onto your account, their creditors come with them. How many of us want more creditors? A child gets into a car wreck and all of a sudden your house, your bank account are at risk. Probably not the way to go. No control with the joint tenancy. As soon as a child turns 18, for instance, if you put money in an account with an 8-year-old, at 18 they can get the money. And the first thing they do is they open a college savings fund, right? Probably not. What's an 18-year-old believe a good investment to be? Does it look a little something like this? Yeah, we were all 18 once. So I'm going to show you one example of a trust. And I want to start by saying you'll only know if a trust is right for you by sitting down with an attorney that you trust in your jurisdiction to give you proper legal advice. I'm not telling you you should have a trust today, and I'm certainly not telling you what your trust should say. You need to get proper advice, again, from an attorney in your jurisdiction. I'm going to give you one example, though, and things that you want to bring up with whatever lawyer that you decide that you want to meet with. And by the way, as you're looking, be on the lookout for what I call the boilerplate of the one-size-fits-all firm. Every year, I recreate several trusts that were created in a boilerplate fashion. They were 5, 10, 12-page documents. They all pretty much say the same thing. And they saw a program of mine, and they said, Ted, I don't remember talking about this stuff with our counsel, and I don't think any of that's in my plan. So we wind up redoing it. I feel a little bad because what they did, they don't get any credit for. We're starting pretty much from scratch. So you want to avoid that. And how would you know if you're going to wind up with a boilerplate plan? I don't know for sure, but I can tell you a few things that have been common to the clients that have come to us, see us. So one is the lawyer said, this is what we charge everybody. They knew before they had talked to the lawyer at all exactly what the plan was going to cost. And again, that was kind of a good telltale sign. I think you can probably figure out why. The other thing out here is that, maybe they didn't know exactly, before they talked to anybody, but they knew prior to a thorough consultation what it was going to cost. They talked to them for a few minutes, or it was a half-hour consult or an hour consult, and they said this is what it's going to cost without a thorough consultation. Again, I think you can see where it's not likely that something's going to be customized for your situation under those circumstances. The other problem is, generally speaking, when someone comes up with a fixed fee they charge everyone, they cut back on services. So one of the services you need when you have a trust is funding the trust. So funding does not mean buying anything new. It means taking what you own, which has your name on the account right now, and changing the name on that account to your name plus the words living trust and the date. That's called funding the trust. Think of the trust as a bucket, and funding the trust is filling up the bucket. so that when you kick the bucket, there's actually something in the bucket for the trustee to take care of, right? So we got to make sure that trust is funded. Boilerplate firms, generally speaking, give their clients a list of forms and say, here, now you need to make sure your trust is funded. By alternative, us and firms like us will give you assistance in that process. So our clients get written instructions on how to fund their trust, access to the office, phone calls, emails during that funding process. And if some clients want, we'll actually fund the trust for them. It's an option. Not everybody needs that option. But if the trust isn't properly funded when you pass away, you're going to have probate. And I would submit to you that to many people, that's probate in disguise. So bottom line is, if there's different types of cars, there should be different types of trust to meet the unique needs, wants, desires, and aspirations that you have for you and your estate. Problem with probate is a problem of ownership. If you own it jointly, if you get sick, you've got disability probate, and on the second death, it's death probate. An individually owned property is probatable on the first death. Is there a better way to own property? For most people, the answer is going to be yes. Now, you're going to see this slide about a dozen times. This is foreshadowing. I will eventually explain all the circles. I'll add some arrows. This will be a trust created for a married couple in Illinois looking to save estate taxes. I will also show you how to do a trust that doesn't need to save taxes, and I will show you a brief analysis of how you might also look at taxes and no taxes and probate avoidance in a state other than Illinois. But once any trust is created, I don't care where it is, you have to retitle the accounts. And again, we've been talking about this. That's funding the trust. So the two yellow circles now are highlighted. What are the instructions, the babysitting instructions? You might say, well, hey, if I'm sick, take care of me. But not just me, take care of my spouse and my dependents. I've got some young kids, or maybe taking care of a parent or a grandchild. And let my spouse sign for me. Let them be my trustee. But let me stop for just a moment. If you think about it, each one of these items could be different, right? Maybe you're not going to take care of a spouse. Maybe you don't have dependents. Maybe you have different kinds of dependents. Maybe your spouse shouldn't be your trustee. Can you see how with just these 3 line items, there's no way for me to make one trust fit all of you? I promise not to do this on every slide, but I want to hit at least on this one. The boilerplate plan can be very dangerous. What about when only one spouse is alive? Are we going to put money in a family trust for the spouse and the entire family to share? Or a marital trust just for the spouse? Are we going to take care of dependents? What about minimizing taxes? Well, we don't want to pay taxes if we don't have to. And then let my trustee, here we're saying again, let the spouse be my trustee. Now, where the rubber really meets the road between what I call a boilerplate trust and something custom created for your situation is this last set of yellow circles. These are subtrusts created within the original trust for the purpose of providing benefits to beneficiaries long after you're gone. Let's just go through a few examples. The common trust circle, what's that for? Let's say that when you pass away, you've got more than one child, and the youngest one hasn't finished college, assuming that you wanted to pay for that kid's college education and you already paid for the older child. Would it be fair to split the assets in half, with the older one getting half and their education paid for, and the younger one getting half and having to pay for it out of that? Well, if your answer is no, then we might create a common trust to hold it all together until the baby gets out of school. And then we make a division. Maybe you say, Ted, I'm not worried about that. My kids are older, and many of my clients have grown children. Why would you create a trust for a grown child? Let's say that you have a daughter, for instance, and you die, and in a boilerplate plan, she gets half of your estate. Looks great. But what if her marriage fails after that? Where's your money going to wind up? I guess we don't really know. But if you created a separate subtrust for that daughter, your money could be in there. She could use it for herself and for her spouse while she's alive. But if her spouse leaves her, you can't take any of that money with them. You might say, Ted, I'm not worried about any of my children or their spouses. But so why would I leave money to a child that's got a spouse? And I would say, well, how about this? You got grandchildren? Yeah. So you leave money to your child, and the child dies before their spouse. Who's going to get the money? Well, the spouse. What about the grandchildren? We talked about this earlier, right? What if that spouse, your in-law, remarries, And now you've got these grandchildren over here. And then that in-law of yours passes away. Could the money wind up in someone else's family? Again, a reason to keep a trust going. You see a circle there for grandchildren. Why would we want to do that? Because maybe we're afraid that our grandchildren won't be able to get to college. Our kids, they're not doing quite as well as we, and so we want to make sure our grandchildren get to school. So we create up a college fund that doesn't, pay out but for school and maybe emergencies. You see a circle there for charity. So this is where Paros Foundation might come in. In fact, that's how we first got together. Our Give Back program, this doesn't have to do with the circle, but our firm voluntarily donates 5% of our legal fees as a discount to our clients. If they want to make a contribution to a charity of their choice, we'll take up to 5% off of their fees. And in this particular case, we got to Paros because one of our clients wanted to favor Paros with a donation, and then things led to where we are today. But you might want to create a sub-trust in your plan that provides yearly payments, monthly payments, however you usually make payments to Paros, or you want it to be described to go for a particular project. One of the things that Peter was talking about is the multitude of great projects. And one of the great things that I like about when I look at the Paros site is that there's not anything that they're doing there that you couldn't get excited about. And they're all projects that by and large are manageable, doable, trackable. It's not like you feel like you're throwing money at some big project and you're not going to make a difference. When you give to Paros, you know that you're going to make a difference and you can track it. And so maybe that's going to be something that's paying on as a legacy long after you're gone. I fully expect that the work that we're doing with our clients now in this arena are paying benefits to those that I'll never see. They'll take effect maybe long after I'm gone. So at any rate, those are things to start to think about as well during this process. Others could be a niece, a nephew, a brother, a sister, a mom, a father. Now, if you're single, widowed, or divorced, or you're in a community property state, you might be advised to just use one trust. Generally speaking, that's going to bring your cost down. That's good. And in Illinois, most of our clients don't have a taxable estate these days, so we're recommending single trusts, even for our married couples. They might say the instructions: take care of me, take care of us. If you're single, just take care of me. Take care of my dependents if you've got them, or our dependents if you happen to be married, and then let the trustees sign for you. And again, it could be children. If you're single, maybe you don't have children, you're using a corporate trustee. This could be your favorite bank and trust. It could be your brokerage firm that has a trust company embedded within it. And then again, at death, now you're looking at those separate sub-trusts. So this is very similar. I'm not going to go over this again to the first set of slides, but these are the sub-trusts. These are the pieces that typically bear the most customization in plans that we do for our clients, and something that you should spend a lot of time on looking with your attorney as well. Bottom line is that if you choose the trustees, the people that can sign your names, then the court doesn't get involved in that decision. Now, a trust has 3 positions. They're called different names around the country. First one might be trustee, trust maker, that's the person making the trust, that's you. Then the trustees are the babysitters, so you take care of yourself in the beginning, so you're your own babysitter. And then the beneficiaries, these are the ones that get to spend the money. Now, if you could just be one of the 3, which one would you rather be? My guess is you probably want to be the beneficiary. What we're going to do now is hit reset, and we're going to play this program forward again, only this time they came to a meeting with us. So if you come to our firm, we do a free 3-hour consultation, or a little more if we need another one. Zoom meetings sometimes take a little bit more to get things designed. But that first meeting is complimentary, and at the end of their meeting, Bob and Pam created a plan where they wanted to be the trust makers. Remember their goal: control everything together, so they're co-trustees. And they made it very clear to me that they wanted to be able to spend all of their own money, so they're the beneficiaries as well. They occupy all 3 positions, and it looks like they have total control, doesn't it? And that's because they do. When you create a revocable living trust, you have total control. There's no new taxes. You'll file the same tax return using your own Social Security number, no new numbers to remember. And since they're revocable, you can change them whenever you wish. Remember our example: Bob got sick. What did Pam want to do? She wanted to sell the house. So let's look at the chart. So now Bob is highlighted. Who's the trustee of Bob's trust? Pam. Can she sell Bob's house without going to court? Yes, because he gave her that power as a trustee, without attorneys going into court, without becoming his guardian. Can he take care of but can she take care of Bob's needs? Of course, that's what he created the trust for, but also to take care of her, because he would have made her a beneficiary of the trust. Now, Bob passes away. Does the trust avoid death probate? As long as the trust is funded. Again, funding is very important. Now you see the arrow going from Bob's trust down to the family trust, because maybe he wanted to put it in a trust to benefit his kids and his spouse. Maybe the marital trust just for the spouse. But again, the spouse, in this case Pam, is taking care of everything without attorneys going into court. There's no executor's fee. There's also no time delay or public record. So average probate takes about 1 to 2 years. This there's no probate here, and it's done on the time frame of the trustee. There's nothing forcing them to do anything very quickly. If there are taxes to be paid somewhere along the line, there might be some deadlines for that, but we're talking today about trying to eliminate those taxes. It's not public. Trust. Only person that knows about a trust is the person that you tell, and the trustees that would be in charge after you pass away. And by transferring property out of state to your living trust, you won't have any out-of-state real estate probate either. And this is part of, again, our Wealth Counsel network of attorneys around the country. No matter where you own real estate, we can get it transferred into your trust. If there were taxes due, they would be due 9 months after the date of death. But in our case, we're using both coupons and deferring any tax, as you'll see in this example, eliminating all the tax through the second death. So there's no first spouse tax and federal or state. Pam becomes disabled. So now we're back up on top again. So Bob can't be the trustee. He passed away. So who's the trustee for Pam's trust? Probably Susan, right? So she was the perfect child. So can she take care of Mom without attorneys going into court or becoming the guardian? Obviously, as long as everything was in Pam's trust. And is she taken care of? Well, those are the instructions of Pam's trust. And what if Pam's trust also says pay $100 a month towards Grandma's landlord because Grandma has trouble making ends meet? Could Susan, the trustee, now make payments to Grandma's landlord? Of course, she'd have to. She's called the fiduciary. Alternatively, would the court have allowed that in the first example? No, because money to Grandma's landlord does not benefit Pam. So, again, we've got this fiduciary responsibility. Susan would have to follow the instructions. Pam dies. Does your trust avoid probate? Again, if everything is in the trust, then everything is flowing down. So now you see all arrows flowing down to those yellow circles on the bottom of the chart. This is when those subtrusts are activated. Again, you would not see these subtrusts by definition in a boilerplate trust. All happening without attorneys going into court, no executor's fee, no time delay, no public record, and no probate in any other states. What about the taxes? Well, in Illinois, which is our example today with the two-trust strategy, we're going to utilize both coupons. 2 trusts, 2 coupons. Pretty easy to remember. That means your federal coupon is now doubled up to $23.4 million, and the Illinois coupon doubled from $4 million up to $8 million. Again, in your state, we would either be working with co-counsel in your state to get the best tax benefits that we can, the 2 coupon strategy according to that state's laws. I know that on the federal side, no matter what, we'd be able to get you in a married couple situation with 2 coupons. How does that happen? Well, when Bob passed away, the arrow goes down to the family trust. You'll see no arrow going over to Pam. She didn't get it directly, but she had access to the family trust. She could have spent it all, but in our example, it doubled. But we got use of the coupon when the arrow went from Bob's trust down to the family trust. So coupon used, no problem. So when that family trust goes down to the family later on, there's not going to be a tax on that. Pam's trust, you'll see the arrow going straight down to the common trust. And when that happens, we're going to utilize that second coupon on the second death. So that's physically how this happens in the 2-trust strategy in Illinois, separate property state. You do it somewhat differently, similar theory, but somewhat differently in a community property state like California, which is why we're doing the second program, or any of you that are in the Pacific time zone. So our trusts will go on, our trusts, the way we create them, for many purposes. We talked about benefiting minors. We don't want money to go on it, all the money to go on a fast car when someone turns 18. So we're going to hold on to it, and maybe we'll stagger the distribution. Some at 25, some at 30, some at 35. We've talked about protecting money from divorcing in-laws, right? Already. Protecting money from an elderly person, who's getting taken advantage of. So maybe you know that you don't want the money going directly to your elderly parent. You want your brother or sister to watch it. You set up a trust for your mom or your dad that your brother or sister would watch for their benefit. Protecting money from a spender like John. We've created trusts, one in particular that I can remember, that we said the beneficiary, John in this case, would not get money until the age 65. And then they get 1/20th for the next 20 years because they're not sure that that child will ever have an IRA and they don't work enough to get big Social Security benefits. So they've created a plan to help that child. Protecting the estate from the creditors of your children. If you have a child that's a doctor, a lawyer, an architect, those are 3 professions I know of where you cannot avoid personal liability for mistakes. So if any one of those kids gets sued, they could get wiped out. But with the right type of creditor protected trust, they wouldn't be able to get to the inheritance that you've left them. Could be very important. You could literally save that child from going into ruin. Protecting money for the bloodline. You want to make sure that money goes down into the grandchildren if a child dies as opposed to an in-law. We talked about that as well. Maybe you've got very successful children and they're not going to need your money. No, they might want it, but they don't really need it. And if a child gets money they don't really need, if they just save it, they had this much estate and now it's this much, and then they live another 30 years and it's this much. And if the taxes started about here, well, there's a bigger tax problem because part of your money is getting taxed when they die. What if I told you instead you could create a dynasty or legacy trust and have that money on the side for that successful child? If that child needed it, great, they'd use it. But if they wanted to grow it, they could pay it forward when they passed away to your grandchildren with 0 death tax. Maybe that's something to look at. Are any of the things that I just mentioned going to be appropriate for every single client? No. 2 or 3 of these things are going to be appropriate for many, but different 2 or 3 for each one because of different circumstances. Again, stay away from the boilerplate plan. So, what if your trust survived you for 100 years? What kind of benefits could be out there? Or better yet, what if 100 years ago your ancestors had created a trust for you? You might say, Ted, that doesn't make any sense. No one ever died and left me anything. And I might tell you that could be a true statement, but not an accurate statement. And let me tell you what I mean by that. So I stand before you today, not because anyone died and left a lot of money. I'm the first person in my family to graduate college, let alone law school. How did that happen? Because every ancestor going before me made a sacrifice to try to make it better for the next generation. I'll bet your story's not that different than mine. So your ancestors did leave you something, didn't they? Opportunity. And you're listening to this program because you made the best of that opportunity. So I help people who've made the best of that opportunity make it even better as the proper steps for the next generation. Planning like your parents and grandparents did probably doesn't apply to you. Most of my clients are first-generation wealth builders. They stood on the shoulders of the ancestors that went before them and made it better. And now they're going to leave it even better for the next generation. So how do you plan? I don't know, but that's what we'll sit down and figure out. And that's what you want to do with any lawyer that you sit down with. Look in your heart. Look at what's important to you. Look at your charitable intentions. If it's your intention to pass along a charitable spirit because you've been given to Paros already, what's a good way to do that? Maybe a trust that your children continue to manage long after you're gone. Again, just a suggestion. There are many wonderful benefits that you can leave behind if you sit with your attorney and discuss what your situations are. I want to remind you right now of our phone number, by the way. We redid our slides for this year, so it's 847-940-7780, 847-940-7780. That's in Illinois here. If you want to toggle back to the evaluation form, you can fill that out. And if you do, let me tell you what's going to happen. Michelle from my office will reach out to you, and she'll schedule you an appointment. And what's going to happen in that appointment is as follows. I'll review your current plan. If you don't have one, I'll tell you what the state has involved for you. We'll estimate your probate costs and your tax liabilities if you've got them. But more importantly, listen to you and design your instructions, answering all of your questions. So at the end of the meeting, I've typically got anywhere from 2 to 4 strategies for the average client with various price points depending on levels of sophistication once I understand what you want to do. You can decide what you want to do from there, but there's no cost for that meeting, all right? Even if it goes up to 3 hours, there's no cost for the meeting. And again, if you want that meeting, or if you don't, if you could please make sure that you fill out your evaluation form. At least let us know how we did today. We kind of tripped a couple of times at the first program, and so I expect a couple of comments there. But if there's something that I said that confused you today, if there's something else you wanted to hear about today, please tell me. I'm continually looking at what people tell us on our evaluations to try to improve what it is that we do. I want to give you an idea of fees. So in our firm in Illinois, the general fee range for this type of work is somewhere between $3,000 and $11,000. Our average client spends between $35 and $65. We are within that range, though. We've never charged $11,000, however, but we hold that out as the possibility. Wills are usually going to be something less than that. But again, our first meeting is always on a complimentary basis. If you're scheduling a meeting with us, I'd like you to please consider the time that you schedule it so that you don't have to reschedule it. Reschedules almost always leave a hole in the calendar that we can't fill. So please, when you're ready, we'll be here. But if you're not ready, just tell Michelle you're not ready, and we'll schedule you when you are. We are doing in-person and virtual meetings. Prefer right now virtual. I think that's the best thing until we've got this pandemic under control. But we are very safe. If you decide you come into the office, we do have filter in the office. We sanitize before you get there. We will be more than 6 feet apart, and we will have a plastic screen between us. So if you want to do it that way, that's fine. I actually, as soon as we started to do in-person meetings, I haven't done that many. There was actually a client that came in that tested positive a couple of days later. There was no transmission. Everyone tested negative after that. So we were all feeling very comfortable that we put in place the proper protocols. We'll ask you to take your temperature and the usual questions that you ask people these days when they're coming out. The way to avoid all that is really to do it virtually. So that's probably the preferred way to do it right now. But we are considered an essential service, so we do need to sort of make accommodations for people who do need to see us face-to-face. Sometimes just doesn't work virtually, especially with age and technology. Some people just aren't able to do that. So we're going to be safe and accommodate in whatever way that we can, but right now virtual is probably the preferred way to go. So this is all of our information as well. I'm going to leave that up there for a minute in case any of you want to copy down any of that information. Once again, you can still toggle back from the original page, and you can see a place to fill out an evaluation form and send in any questions. I did not ask for questions, however. I don't know if anyone sent them or they saw a place for questions. I'm going to leave this screen up here for just a minute, and I'm going to invite Peter to come back in as well. And if you've got questions, come on in and put them up. I know Peter had one at the end of the last meeting, and we might go over that. So in just a minute or so here, we should have Peter back up in a Zoom call. And once again, I just want to mention our phone number in case you didn't get it off the site or anywhere else. It's 847-940-7720. But again, you can click back over to the webpage if you want to meet us. And again, we can work with attorneys around the country. Peter, are you back with us there?
I am back.
Wonderful, wonderful. So I think we nailed it this time. I felt pretty good about the first program, but tonight I felt a little better. At any rate, I don't think that we had any questions. I didn't solicit them earlier. That may be why we didn't get them. But do you have any questions that you might want to pose or any other things that you might want to ask?
Well, it's an interesting thing. I'll look at my own personal our family situation here. When our children were young, we thought, okay, we really need a will. And then when we bought our home, we decided, we should look at a trust, and we set something up. It took longer than we expected as far as us making the decision on when to pull the trigger and do set up our family trust. And now that, our kids are a little older, we're thinking about it's probably time to go ahead and update that, or at least take a second look at it and see, what's changed and which kid we like better than the other, et cetera, et cetera. But I'm sure people are going to ask about that. When, what point in their lives is it time to set up a trust? What time is it, or is it time to set up a will? And, probably the big question in the Armenian community is whether or not we can decide who our children marry. We're very true to our bloodline whenever possible, and I'm sure that question might come up as well. So if you could take a second to answer those, I think our
Sure.
viewers
Well,
will be.
let me start with sort of like where you're at with regards to updating. And I will tell you that the industry standard is 3 to 5 years. These tax laws have been changing continually. And I know if you're in Illinois and you have a plan that predates 2009 and you're tax sensitive, your plan needs to be relooked at, perhaps even redone altogether, because the tax laws, there was no Illinois death tax. And many states did not have their own death tax in years past, and they do now because their revenue's short. And the federal number has been changing continually since 2002, and there's going to be a big change in 2026. So if you're banking on the fact that you're under $11,700,000 and you're not worried about taxes, well, if you're going to live past 2026, that's not going to hold, because without the government doing anything, that law expires. So that's the answer to the first question. The second part is sort of when's a good time to do it. And I would say that basically as you turn of majority, because even at that point, who's going to make a medical decision for you? I have clients who will send their kids off to college, and I'll say, look, you got to have a medical power of attorney. If they go into the hospital at school, you can't even talk to the docs at that point. There's privacy issues at that point. So that's even the starting point of some sort of planning, right? All of our clients get all of those documents, the health planning documents and things at the same time. And then from there, it's when you start to accumulate something. So I have clients that I've planned for as young as 18 years old, where my clients had already given money to their kids, and they were afraid that as they grew, that money might get wound up in a marriage, and now they've got literally hundreds of thousands of dollars, and they want the kids' money to be protected. So they had the kids create trusts for themselves that will act like a prenup when they get married. Now that's kind of the unusual situation. So more common would be someone buys a house or they start a family. So now, again, what's going to happen to the house? Who's going to take care of the house? More importantly, who's going to take care of the kids? So from my perspective, that's kind of like a point where it really makes sense. Taking care of money, okay, we take care of money. I get it. But the bottom line is, if you got minor children and you don't say who the guardian is, you're leaving it up to a stranger in a court somewhere to decide, among people who might be fighting it out, who's the best person to care for your kids. Even a simple will at least take care of that. That's done in conjunction with a trust if we do a trust for someone. So then from there, we get into kind of the situation that you were talking about, Peter, where people put it off till the kids got older, and then they finally got around to doing it, right? And then again, we'll see them, a tranche of people coming through right around retirement, because by then, they're a little more in control of their own schedule. They know a little bit more about what's happening, with the family and the in-laws and things like that. But those are kind of periods of time, and we kind of see it like most things. It's kind of like a bell curve, starting at very young ages and then kind of peaking in around retirement ages, with kind of 50 being the sort of the start of the tipping point. And I think, at least myself, it's like we sort of think, well, maybe I'll live to be about 100 years old, right? So once we tick over 50, we figure, well, half of my life might be in the rearview mirror. Maybe I better get something done. And don't be embarrassed. No matter what attorney you go to, I promise you, they will have heard the story. I've been thinking about this for years. If I had a client, for every client that told me that, I would literally have twice as many clients. So, so don't be embarrassed about it when you go in. It's never too late. You're still alive, so it's not too late. So those are kind of the time periods. And then as far as, I don't know if this was tongue in cheek or not, but in terms of like who they might marry in the ethnicity or not. So you got to kind of look. The rules basically are, there's no rules for estate planning. It's your money. And if you think of yourself as alive, and if you were to tell your kid, if you marry this person, I'm not going to give you this money for a wedding present. You've got a right to say that, right? Now, many people might not think that's right, but it's your money, and you've got a right to say that. So basically, if you've got a right to say it while you're alive, you've pretty much got a right to say it in your plan after you've passed away. So the rule is basically, as long as it's not unethical or against public policy. So there's public policy thing might be where you get into a little, if someone were to challenge it after you passed away, they might have an argument to make there. But I'll give you an example. So when I was in law school, and this sounds very, very sexist today, there was a estate plan that we studied where the spouse, in order to gain access to funds, needed to go into a banking facility that was the trustee, smoke a cigar in the lobby, and then they would be able to get a withdrawal. And the purpose behind it was the person who made the trust said, my spouse never let me smoke at home, so I always went to the bank, and that's where I sat in the lobby and I had a cigar. Now, obviously, today, that wouldn't take effect, but I say that to just kind of dot the I to say it's your money. And within reason, and against, if it's not against public today, that would obviously be against public policy, right? You can't stand in a bank and smoke a cigar, that type of thing. But if you can think it, if you can dream it up, and a creative estate planning attorney should be able to make it work. Now, that doesn't mean they're gonna do it. Sometimes a client will tell me they want to do something, and my job is to counsel them. So here's what else could happen if you do this. So a good attorney shouldn't just be a scrivener taking your directions. They should be counseling you on their experience. So, we have got somewhere between 3,000 and 4,000 clients that we've done plans for these days. And so, when you hire us, if you decide to do that, you're tapping into all those family stories and scenarios. And guess what? All of our clients aren't alive anymore. So we see what happens after people pass away as well. So I know we've gone a little bit over the time limit there. But was there anything else that you wanted to bring up, Peter? I'm okay going longer. If anybody.
No, you did an amazing job presenting this as an overview for people to start thinking about this, and our Paros family members to, honestly, we're doing this as sort of a service for everybody, right? It's a well-planned house is a well-planned house, and I know the struggles that we went through as a family, and I think that it's a good thing for everyone to talk about. It's the beginning of the year, and nobody likes to talk about this, but certainly it's important to do. And I very, very much appreciate the time you've taken throughout the afternoon and evening today to do these. And thank you so much. It was a wealth of information.
Well, it's my honor. And for those of you who have been on the program today, we'll be paring down. There were 2 programs, so it's actually going to be like a 4-hour video out there right now if you go to click on it. So give it a day. We'll pare it down to one of the 2 programs. I think it'll probably be the second program for people to be able to watch. So you can give that to a friend or an associate. And if I'm lucky enough, maybe Peter will invite me to come back and do another live one. I prefer the live ones because unlike tonight where we didn't get any questions, it's nice when we get some questions and you can interact. When you go to watch it, it's not really, I don't think, nearly as powerful. But at any rate, thank you. I'd be blessed if you'd have me back again. Thank you for having me here tonight. Peter,
Absolutely.
out in California, stay safe. All right, buddy? Peace be with you all. And if you decide to come to see me, great. If not, take some steps in the direction where you're at and find counsel that you feel comfortable with. Good night.
Good night. Thank you.